So Amy Schmitz and I are going to be moderating today. We're really excited for this program. I think that we'll be covering some very important ground, the ethics of NDAs in mediation and arbitration. I'm going to go ahead and do a few brief introductions, and then our plan is that we will have each of our presenters present briefly regarding how they became involved with this issue and their primary points for all of us. We'll have a little dialogue then among the presenters, and then we'll be turning to all of you for any questions that you have. If you do have questions, I think that I am going to recommend, Amy, feel free to disagree with me. I think I'm going to recommend that you go ahead and put your questions in the chat because we are going to allow everyone to speak and then have a little dialogue before we turn to audience questions. And if you've put your questions in the chat, then it's more likely that you'll remember what your questions were. It also will give our presenters a little bit of an opportunity to see what the questions are and prepare to answer them, perhaps in a more organized way. So on to the introductions. So first of all, I'm going to introduce Julie McFarlane. She's Distinguished University Professor Emerita at the University of Windsor and has held positions on the faculty in Ireland as well as England and numerous visiting appointments all over the world. Julie has written several books, including The New Lawyer, How Clients Are Transforming the Practice of Law, Islamic Divorce in North America, Choosing a Sharia's Path in a Secular Society, and Going Public, A Survivor's Journey from Grief to Action. Julie has received many awards for her work, including the International Academy of Mediators Award of Excellence, the David Mundell Medal for Legal Writing, and one of Canada's 25 most influential lawyers designations. In 2020, as a high honor, she was named to the Order of Canada. She's also co-founder with Zelda Perkins of Can't Buy My Silence, which campaigns for a change in the law on the misuse of non-disclosure agreements. So Julie will be sharing more on that with us in just a bit. Delighted that she's able to be part of this, this panel and a driving force, I think, with our focusing on this issue. Jody Newman is an employment lawyer with Boston Law Collaborative. She also is an independent investigator and mediator with more than 35 years of experience in resolving workplace disputes and investigating bias and sexual misconduct across workplaces and college campuses. Her deep experience resolving employment disputes is unique in that she spent most of her career representing individuals in a boutique litigation firm, and then more recently has served businesses in the Boston office of a large global law firm. Her experience includes numerous jury trials, non-jury trials, administrative hearings, and appeals.
RED.
And she was an early adopter of ADR and collaborative law practices. If every once in a while you hear a voice that doesn't sound like mine, it probably isn't mine. So if I pause, that's why. Jody's experience includes representing individuals in all sorts of industries, from the trades to the C-suite, and she's well-versed in helping employers avoid being sued through best practices. She also is somebody who has been involved in helping employers deal with revelations as a result of the Me Too movement and ineffective existing sexual harassment policies. Brian Farkas, our third presenter, is an attorney at Aaron Fox. He's focusing his practice on complex commercial litigation. He represents clients in state and federal court, as well as in arbitration and mediation proceedings. He's been named for 5 years as a rising star by super lawyers for business litigation. Previously, he had served as a judicial law clerk to the Honorable Robert Lehrberger of the U.S. District Court for the Southern District of New York, and as a litigation associate at a mid-sized firm in New York City. Outside of his practice, he's an adjunct professor at Cardozo School of Law. He teaches dispute resolution there. And in 2021, he was voted best adjunct professor by the student body. He's written for law reviews, and this writing includes focusing on arbitration and mediation. I am also going to introduce my co-moderator, Amy Schmitz. who is professor at the Ohio State Moritz College of Law and program on dispute resolution as the John D. Drinko Baker and Hostetler Endowed Chair in Law. She's also affiliated with the Ohio State Program on Data Governance and the Divided Community. She taught previously at the University of Missouri and at the University of Colorado's law schools, practiced law with large law firms in Seattle and Minneapolis. She's been heavily involved in arbitration and ODR, and I think for many of us is one of the people we look to, along with Colin Rule, for her expertise in online dispute resolution. And I am Nancy Welsh. I am a professor of law and director of the Aggie Dispute Resolution Program at Texas A&M University School of Law. My focus has been on court-connected dispute resolution, including negotiation, mediation, judicial settlement conferences, and the intersection between the courts and arbitration. And with that, I think I've come within time for our introductions. And before we move to each of the presenters, we wanted to provide a little bit of information regarding the scope of the program, exactly what we will and won't be covering as we look at non-disclosure agreements. And for that, I turn to Amy Schmitz.
And here we go. So as you know, we are talking about the different ethics of NDAs and mediation and arbitration. And I just want to very much thank you, Nancy and Texas A&M, as well as Mediate.com, Arbitrate.com, and Ohio State, all sort of joining together for this really important event and important discussion. So moving along here, I'm going to get my next slide. Isn't that perfect when, you know, the technology person is kind of not doing great? All right. So I've actually talked before in my own research about the privacy paradox in arbitration. And when we talk about arbitration, it's private in the sense that everyone is not allowed to just kind of come in, but it's not necessarily confidential. But most ADR agreements do include confidentiality clauses, right? And settlements often, usually include NDAs. So that's why we hear a lot about secrecy and the confidentiality of mediation and arbitration. But it is by contract that happens. It's not just simply by nature or by law, which I think is worth noting. So when we think about what can be covered by an NDA, there's so many different things within that universe. You have trade secrets, intellectual property, customer lists and other proprietary information, injury suffered as a result of product malfunction and consumer claims. A company might want there to be an NDA. Also misconduct in the workplace. And the actual recovery amounts and settlement terms will often be subject to NDAs. And really anything else that parties want to keep secret. And the truth be told that NDAs and non-disparagement clauses as well are very, very common in all sorts of areas. And we're used to seeing it in these sort of communal areas, such as business to business and trade secrets, intellectual property. But we can't cover the universe in this discussion. And so the focus today is going to be solely on the workplace issues and looking at NDAs in the areas where you're talking about misconduct in the workplace. So specifically discrimination, harassment, assault. So we just wanted to be clear that we're not covering the full panoply of all the different things that might be subject to NDAs and really are focusing on the workplace area. Hopefully that sort of clarified the scope and didn't mess up too bad on the slides there.
Thanks very much, Amy. Appreciate it.
And
so
I'll be watching the chat, just so you know.
Great. Thank you. So we're now going to go ahead and turn to our three panelists, and we're going to start with Julie McFarlane. And remember, each of our panelists will be letting you know a little bit about how they became involved in this issue and then what their primary points are. There's so much more each of them could say. We're restricting them to a relatively short period of time at first. Julie, go ahead and take us away.
Thank you very much, Nancy. I'm just going to say a little bit first of all, in addition to what Nancy's told you about my background, about how I got involved in this issue. I am the academic, I am the professor on the panel here. However, my work, those of you who know my work know that I've actually spent my entire career studying what lawyers do in practice. So I'm not a practitioner, but I spend my entire time messing around in those waters. And I have been, the entire time that I've done this work, extremely convinced of the need for empirical data to ground what we talk about in the legal system, what we talk about as mediators. And in fact, Nancy and myself and a number of other female professors described ourselves, I think this was in the 1980s, Nancy, as the data chicks, because in those days, there were not that many people who were actually collecting empirical data about the way that the legal system worked and the way the practitioners worked with their clients. So that's where I'm coming from. And you're going to, I think, see that reflected today in quite a bit of what I say, because I have now spoken to literally hundreds of people who have signed non-disclosure agreements and regret it. So a great deal of what I say, and this will be obviously in contrast to my colleagues in practice, is going to be reflecting those kinds of remarks that I've heard and the information that I've collected, both on my own and now more recently through the Can't Buy My Silence campaign that I'm going to tell you a little bit about as well. I came across NDAs in two ways. They came into my life, if you like. The first was when I was bringing a case for historical sexual abuse against the Anglican Church. I was sexually abused by an Anglican church minister, and I knew very well that I would be asked by the church to sign an NDA. And I basically went into our negotiations saying, don't even bother, I'm not signing one of those. So that was the end of that issue in that particular case. And I also persuaded the insurers for the church to draw up guidelines that said that they would at least limit their use of them in future. But then the issue came back to me in a different way, because I was then, as a colleague at the University of Windsor Faculty of Law, I began to receive phone calls from other law schools about an individual who had been terminated by my university for harassment of students. I knew a lot about this issue. Students had come to me, and he had left following an investigation. And I was shocked, as I can imagine anybody else listening to this would be, to receive a phone call asking me, why did he leave the University of Windsor? Because he was now applying for a job at this other law school. So I told the truth. I didn't sign the NDA, but obviously one was given to him. And eventually I got my hands on that document, and he was given abolition from his sins, if you like, by the University of Windsor, so he could pass on unknown to another law school. The story gets much messier than this, because he then sued me for defamation. The university hid the documents behind the NDA, et cetera, et cetera. I'm not going to spend any more time on that today, because I have a few other things that I would like to say just to get us started here. So as Amy's talked about, this is a contractual matter. An NDA is a contractual agreement where the parties will agree not to disclose particular information to any third parties. And I want to be really clear about what we're talking about here, because what I've seen during the work that I've done on this issue now is a lot of confusion about some of these terms. First of all, an NDA is permanent, it's indefinite, it's forever. That's really important. Typically, it prohibits any communication, not just about the settlement, but about the complaint that led to the resolution. And this is what's really important. And that typically includes family and friends. It also sometimes includes a professional therapist. These are incredibly broad silencing agreements. We see them happening in three different ways. They might be required in order to enter into a mediation or investigation process, and I'll say a bit more about that in a moment. They might be, this is what we most often come across, agreed as an outcome, or they might be required for access to a decision. So they kind of pop up all over the place. And what I call the first cousin of NDAs are non-disparagement clauses. Amy has already mentioned these. These are clauses that basically commit to never saying anything that would be considered to be negative. It's not a defamatory standard. It's not an objective standard. It's just anything that might be considered to be defamatory. And I would consider a non-disparagement clause to be another version, if you like, of an NDA. But it's important not to confuse this with some other things. First of all, we're used to making time-limited confidentiality for a single process. So, you know, if you go into a mediation, if you go into an investigation, there is very often an agreement that nobody will talk about the process while it's in process. And that is not what this campaign is about, because NDAs are indefinite, they are forever, whereas time-limited confidentiality is a different matter. I'm also not talking about the classic provisions we see in mediation agreements that say that anything that is said in mediation will be inadmissible if it's repeated in a future adjudication. This isn't about that either. That is a very important way to ensure that that cone of confidentiality remains over the mediation. But again, it's a very specific restraint. We also typically, for years and years, while I was a mediator, saw agreements to keep the settlement amount confidential. I'm not always totally comfortable with those, but I can see that they are, you know, something that we have become accustomed to in practice and the parties often ask for. And this is also not the same thing as just protecting the victim. I think one of the things that we often forget with NDAs is that they are by nature mutual. So that means if I promise you confidentiality, you promise me confidentiality. And what's happening in these cases is victims or complainants are being told they can only have confidentiality if they promise confidentiality also to the other side. So a one-sided clause would be perfectly fine. So where did this come from? Well, in the 1980s, with the tech bubble, there was a lot of frustration that the traditional restraint of trade doctrines were always curtailed by the courts in terms of reasonableness. And as you saw all these new platforms and innovations developing, people didn't want their staff taking commercially valuable ideas to other companies. And so what was originally something to protect trade secrets actually came out of this frustration at how limited restraint of trade would be, because again, remember, this is indefinite, this is forever. Now we're seeing them all over the place. So first of all, some lawyers estimate that they are now part of a standard release, an indefinite silencing clause to talk, not to talk about anything related to the dispute or the complaint in 95% of civil settlement agreements. I've seen them in agreements over product liability, construction defects, fraud, all kinds of misconduct, but all kinds of different situations. Typically, an NDA is made between a victim and an employer. That's what we're talking about today in the employment context, or between a victim and a perpetrator. And of course, the interests of the employer and the perpetrator in these contexts is actually the same, because neither one want the damage to their reputation, either as an employer or as a perpetrator, obviously, that there has been such activity, that such misconduct has gone on within this workplace. 1 in 3 American workers are estimated to have signed an NDA. That might be an NDA for their original purpose, to protect trade secrets, but it could also be an NDA around a complaint that they brought about workplace misconduct. In fact, we know that a third, from other data, a third of complainants bringing workplace harassment or bullying claims say that they have been required to sign an NDA either to enter the process or as an outcome of the process. And 95% of them say they have mental health consequences. So I'm going to just go quickly to this point here, which is not what I wanted to happen. There we go. I am working on a campaign with Zelda Perkins, and we are looking to legislative reform, which would actually ban non-disclosure agreements for discrimination and harassment cases that arise in the workplace. And we've seen some of this work being done already in the United States, in New York, California, and New Jersey. There have been moves to ban non-disclosure agreements. And we're also working with a model bill, which we're progressing in Ireland and in England and Wales. And it's just been passed in Prince Edward Island in Canada. And it's about to be introduced in Manitoba, another Canadian province, and possibly in British Columbia and Nova Scotia. I'm going to drop the model bill into the chat, so if people want to have a look at the way that it's structured, and I'm happy to answer questions about that. But I want to just spend one more minute here on the myths, because the myths are so important. And I think that for mediators, and I'm going to address in my later remarks some of the things that I think should be takeaways for mediators. For mediators, we hear all the time, we cannot settle without X. Y is non-negotiable. We've all seen these fashions during the work that we've done about various things that people say are absolutely indispensable. And we hear we can't settle without non-disclosure agreements. Well, we all know that for the last 30 years, the data has shown us that settlement is about 95% in civil cases in every common law jurisdiction. And that was well before NDAs were used as frequently or as widely as they are now. So obviously, it is possible to settle without an NDA if it's taken off the table. Moreover, in California, where they have been banned for harassment cases since 2018, there is no difference in the data in terms of how many cases are settling. Now, I know that might mean that plaintiff's counsel has to work harder, but it doesn't mean you can't settle without them. And if they're not on the table, they're not even a temptation. I hear all the time, victims want these for closure. And I have to tell you from my experience of speaking with people, exactly the opposite is the case, because people generally sign without really understanding what they're signing. It's usually only months later when the dust settles, they start to realize what they've done. And suddenly they realize, I can't talk to my friends about this. I can't go and talk to my therapist about this. And they become, I mean, quite honestly, a little paranoid that they might do something that will break the agreement, which often includes inside very specific penalties for their breach, including taking back their settlement money. So no, they don't give them closure. Victims want their own privacy, but telling them they have to give confidentiality to the other side in exchange for that does not give them closure. People say they signed up and took the money. Well, yes, people do sign up and take the money because, as we all know, as mediators, people want disputes to be over, especially disputes that are as upsetting and traumatic as the kinds of things that we're talking about today. But in fact, if they really thought about what they needed and wanted moving forward, and many people, as I say, come to this conclusion months later, they realize that what they're doing is giving away an important part of how they will recover and heal by taking that money. And in addition, what they're doing by taking that money is letting other people be potentially at risk from the same perpetrator. And this is something I hear constantly from people who signed NDAs, that the whole point of their complaint was to stop this happening to other people. And now they realize, and it may be months or even years later, what they have done is prevented themselves from warning other people or from other people knowing about what happened. And finally, we've all heard this is just the way everybody does this. I can't tell you how many people who signed NDA tell me that this was what their lawyer told them. Sadly, this is not just a problem for unrepresented people, although obviously it's another level of powerlessness in their case. But this is just the way that everyone does it. I don't think is a satisfactory answer to what is effectively treating misconduct in the workplace as if it's a protected trade secret, for goodness sake, and as a consequence, potentially harming third parties and the public interest. I'll stop there, Nancy.
Thanks very much, Julie. I appreciate it. You have definitely helped frame the issue, exactly what NDAs are. And thanks very much as well for providing the information regarding the legislation. And there are folks that definitely are interested in having access to these documents. We are going to turn next to Brian Farkas.
Thank you so much. Thank you, Nancy and Julie and Colin and Amy for putting this together. This is, I thought I was going to be like, I was just like enraptured listening to Julie and learning so much from that presentation. So I feel like I'm back in law school. I come at this question from two perspectives. So one is my hat as a lawyer at a big law firm. So I think the reason that Colin and Nancy and Amy probably asked me to be here is to sort of play the role of the evil defense lawyer who's going to speak in defense of broad sweeping NDAs to try to punish victims. So I am not actually legitimately in that camp completely, or really at all, but I will offer some defenses of it just so that that perspective is represented here, but really more broadly so that the perspective of the business client generally is represented in this conversation. And then the second hat that I wear is teaching arbitration and arbitration policy at Cardozo Law School. So I'm going to divide my 7-ish minutes into two categories. So category one, I want to talk about my views on NDAs generally. Category two, which is more in the teaching policy hat, I want to talk about a really exciting development in arbitration law in the United States that literally is just unfolding quite literally this week. A new law relating to arbitration of certain employment-related claims for sexual harassment, and I'm going to connect that to our conversation today on NDAs. So let me start by talking at the broad level on views on NDAs and NDA policy. So I come at this question really as like a true tried and true believer in alternative dispute resolution, the way that I know so many folks on this Zoom call are. And I see the idea of ADR as being fundamentally different from litigation. If we wanted litigation, we would go to litigation. Many of us, I think, who went to law school or who took classes in law or have been exposed to the civil litigation system see the tremendous difficulties and inefficiencies and bureaucracies with public litigation, which is exactly why after we took our first course in mediation or arbitration, we totally fell in love with it and never wanted to do anything else. And one of the things that I think now we all think about as being, or what the series of things that we each think about as being really compelling in alternative dispute resolution that we tell students all the time. ADR, arbitration mediation, can be quicker than litigation. It can be far less expensive. It can be less bureaucratic, less rule-based. You can apply non-legal frameworks to resolve the parties' disputes. You don't have to worry about precedent in mediated settlements or in arbitration in many cases. You can apply industry-specific knowledge. You can apply the norms of a particular company or a particular industry to the resolution of the dispute. And you can choose. Hello? You can choose a neutral who has experience in your topic. And finally, I think a really important selling point for mediation and arbitration is that it's private. You can find scholarship on the importance of privacy from scholars like Leila Love, Sarah Cole, Jackie Nolan Haley, Baruch Bush, and like everyone who's on this call too, Amy and Nancy and others who are on this call. And I think as a framing point, I am skeptical of this branding of quote unquote secret settlements and NDAs as being cast as being this sort of evil, sketchy clause that is inherently one-sided and is inherently meant to suggest that something evil is being hidden through a settlement agreement or through an arbitral award. I actually think, that those terms are, of course, meant to spark an emotional reaction. And my kudos to Julie for putting together a very compelling campaign, which is making some very important points. But at the same time, I think it is really important to remember that the average case is not Harvey Weinstein. The average case is not an employment dispute that is so inherently problematic that the vast majority of lawyers would see it as being obvious that there's an inherent power imbalance. And in my own practice experience, it's generally true that both sides have a little bit of dirt on their hands. It's generally true that both sides have some good facts and some bad facts. And it's also generally true that both sides wouldn't want the bad facts to be aired publicly. That's been my experience in basically every mediation that I've been involved in. So for that reason, I'm a little skeptical of the branding that that there is something inherently wrong with NDAs or inherently wrong with confidentiality and non-disparagement clauses. I actually think that they're often a good thing, both in the employment context and elsewhere, as long as they're not used in situations with tremendous power imbalances, which I know we're going to come back to when we get into some of the footnotes on each of our arguments later in this session. But I also want to make one last point about this, which is that I think that these clauses that exist in mediation and arbitration agreements, mediation settlements and arbitral awards, I think that they inspire finality, which is another really important distinction between the way that we think about ADR compared to the way that litigation often unfolds. Litigation is, I spend about half my time probably in litigation. It's, as any client will tell you, it's like an endless time horizon. You have the trial, then you have the motion for reconsideration, then you have an intermediary appeal and a circuit court, and you are filing for cert. And it's like 3, 4, 5 years that you're spending litigating claims. And there's this emotional sense, I think, in litigation that it lacks finality. You're never done with it. And I believe that ADR, both mediation and arbitration, that a core value of this field is that the clients can get finality. It can be bargained for. There is a price to finality, and it can be bargained for, as long as both sides are represented and there's no inherent imbalance and unfairness in that negotiating process. I think that there's nothing wrong with that. I probably take an even more extreme position on mediation. I don't think we should ever ban the enforcement of confidentiality agreements or non-disparagement clauses in mediated settlements. And I think that that's true because if the power dynamics were so one-sided in a mediation, then the mediation itself would be considered involuntary and not a mediation at all that could result in a binding agreement. But absent that, I think, again, there's nothing wrong with a process that allows for the negotiation of those terms. In arbitration, I'm less extreme, and I'm probably closer to Julie's points in thinking that there probably are some important statutory protections that could exist to make sure that we don't have situations that are so inherently one-sided. And I think sexual assault, sexual harassment are important footnotes that we could put onto that general premise favoring confidentiality and privacy. Let's see, how much time, Nancy, how many more minutes do I have? Am I out?
You actually are out.
Okay, I'll come back to the FAA later on, and we'll talk about the new Senate bill.
That would be great. And if you don't bring it up yourself, I'll ask you a question about it, Brian. All right, let's now turn to Jody.
Welcome, everybody, and also a thank you to our host today. I think this is a very, very interesting program, and I know I'm learning very much from my colleagues in planning this and presenting. So although I am happily at a law firm called the Boston Law Collaborative, which focuses on ADR, and I love to do ADR, I've spent the bulk of my career representing plaintiffs in discrimination, including sexual harassment litigation. And so my perspective on NDAs for many, many decades was they were a fact of life to get the best results for your clients. And my view was that, sure, settlement agreements are an exchange of money for silence. And I don't think I can ever say those words, money for silence, again, in light of Julie's campaign, Can't Buy My Silence. And that's why it's so compelling. But the notion that money for silence is very embedded in the law. And so my thinking changed on NDAs, along with everybody else's who hadn't been thinking about it previously, such as people like Julie, with the Me Too movement. Suddenly NDAs came under intense scrutiny and fire for good reasons in the extreme high profile case, of Harvey Weinstein. And with the many revelations of the Me Too movement and that I've seen implicate actual practice and enforcement norms, the social media movement really told everybody in the public that sexual harassment is alive and well in the workplace. It hasn't gone away just because we don't hear about it that much. And the existing policies and procedures that have been on the books, in the legal books and in the corporate policy books for decades hasn't been working, because there are a lot of sexual harassment complaints out there and people weren't talking about them. Many people likely because of NDAs. So I'm going to frame my remarks today as sort of somewhere in the middle ground. I don't believe in the wholesale abolishment of NDAs, though I see from a social justice standpoint, they're not good. I get that. And I also don't support the status quo where they're overused, overly broad, without adequate explanation and bargaining. So the way I'm going to frame my viewpoint is, what is the information to be kept confidential? Is it the amount of money paid, the fact of settlement? Is it the underlying facts? And at what stage of the dispute are you in? Are you in an internal process where there's no equal opportunity commission? There's may not even be lawyers involved. And many cases get raised in that context and can be settled in that context, that there's no litigation at all. But in those internal disputes, I find that employers are most adamant about non-disclosure because the claims are simply claims. They are allegations, they are not proven. Plaintiffs, unfortunately, have the burden of proof to prove their allegations in a court of law. And many employers will insist on confidentiality because they're skipping that step of litigation, which is a long and painful process for everybody involved. But it makes it much more difficult to allow the facts of a disputed, unproven claim to be in the public light. Employers also, their viewpoint is that these settlements are public. We're going to be inundated with copycat suits. Copycat suits, and there are plaintiffs, there are victims who want confidentiality, want non-disclosure agreements because they don't want the stigma of being involved in litigation as hurting, or having brought claims against an employer as hurting their career prospects, or they simply are private and they don't want the claim known, and that is what the victim interests are, is legitimate as well. So I think in these cases, the internal complaints that have not been in any way tested or proven, it's much harder to keep the facts confidential than it is in a later stage of the proceedings. So my my approach has been, and my recommendation for best practice is to not take NDAs for granted anymore and really examine what are the interests being protected, and can they be protected on less onerous grounds. I mean, there are standard carve-outs for, you know, your legal advisors, your financial advisors. That's not good enough. I always insist on an immediate family carve-out, and I have seen a recent NDA in a settlement of a case in a major hospital system here that included a therapy or mental health provider or medical care, which I think I don't know where my echoing suddenly. Let's see.
You're muted.
You're muted right now, Jody.
No, I was trying to fix my sound. I'm sorry. So I think with pre-litigation, pre-agency disputes, that being careful about what the interests really are and making the NDA as narrow as possible is, at this point, without broad litigation against them, is the best way to go. Briefly, at the EEOC process and the various state agency, confidentiality is a concept embedded in the EEOC processes. Complaints aren't public, outcomes aren't public. What is public is that there was a settlement or a consent decree entered into. So the EEOC hasn't done anything in the wake of Me Too, perhaps in light of the most recent administration at the time. The EEOC hasn't been moving to make NDAs better. And then in court, at that point, the facts are public. There is a complaint, and although at least a complaint, and obviously if and ultimately there would be a trial that would not, that would also be public. But I think there's no good reason to require plaintiffs' victims to be silent about the facts. And because they're in the public record, and if you didn't want them in the public record, the employer should have settled before you had to file the case. And there's even pushback there that employers will say, well, I know it's in the public record, but she still doesn't have to talk about it. And I think those cases are the strongest to say, no, it is not going to be, the facts are in the public record and they will not be, gagged, essentially. And then I wanted to say a word on non-disparagement clauses. As Julie said, the first cousins of NDAs, and they are clauses that have also become ubiquitous in these agreements. They're everywhere. And typically the company says, you employees shall not badmouth or say anything negative publicly or privately about anybody at the company, any of our products, any of our business practices. You shall speak no ill of us ever. And one thing that can be done there for plaintiffs and victims is to make those clauses mutual, where an individual can commit to not badmouth an entire company cannot commit to badmouth an individual. So in those cases, the lawyer and the plaintiff identify who are the people that know about this, who have the most potential to hurt you in either a potential job search or otherwise. And those people either, generally speaking, get instructed by the employer to not disparage the plaintiff. And usually there's some kind of a script agreed to for a reference, either in the form of a verbal reference or many cases, a letter of reference that forms the script, and a provision that any public or any non-written statements be treated you stick to the script and you don't deviate from the script and you don't reveal any negative information.
Jody? So I think I think we'll see whether there are some additional questions from people in the audience regarding that distinction between non-disclosure and non-disparagement. But what I want to do now is turn to the opportunity for there to be some exchange among the panelists, responses, questions. I also do feel that I should turn to Brian and give him a minute and a half to let us know about this development in terms of the FAA and its relationship with non-disclosure agreements. So Brian, can you do it quickly?
I can do it very quickly.
Great.
So this is a campaign that has been building for many years to essentially amend the Federal Arbitration Act, which is the primary law that governs arbitration in the United States, to include a limitation that says the general law says that usually agreements to arbitrate are valid, irrevocable, and enforceable. And that's the general rule. Courts strictly enforce that. But this new law that was passed by the Congress last week, both the House and then the Senate, and is currently awaiting President Biden's signature essentially as we speak right now, this proposed legislation would amend what I just said, that valid, enforceable, irrevocable piece, to exclude any dispute that raises an issue of, raises a claim of sexual harassment or sexual assault. So in the workplace context, that essentially means that if an employee has a general arbitration agreement with their employer, it's still totally enforceable unless one of the issues that I just mentioned, sexual harassment or sexual assault, is raised in a lawsuit, in which case the employer cannot compel arbitration of the case. So that's the nutshell version of it. I suspect that there will be all sorts of legal challenges to it, but the gist of it is that it's been inspired by the Me Too movement and also by the work of advocates like many folks on this call. I see Jean Sternlight is here, who has written extensively on this, and Julie herself. So I think that that this is the culmination of many people's work over many years.
And so the intersection between this and NDAs, of course, is that to the extent that the arbitration proceedings and awards were themselves kept confidential.
Right. Of course, I didn't answer the one thing that you asked me to answer. Yeah, so the intersection here, there are a couple intersections. One is that I think it will make mediation more popular because it can essentially create an avenue where employers know that they can't force arbitration of employment claims that relate to sexual harassment and sexual assault, but they can strongly encourage mediation of those claims. So I think if you're an employment mediator, chances are that you may see more claims that fall under that category. And the second is, I think generally speaking, you're going to see more hesitation by employers to try to use arbitration of those types of disputes, and maybe even fewer instances of arbitration of employment disputes more broadly, given the public stigma that now has been associated with employment arbitration. So I think those are things to watch.
Great, thanks very much. So this is now the opportunity for there to be some dialogue among the panelists. And so I am going to open it up to Julie, Jody, and Brian. Do any of you want to respond to something that was said by one of the others or ask a follow-up question? And my only request to you is make it short.
Okay, I'm going to go first and I'm going to make it short, but I do want to take on something that Jody said. I think maybe unintentionally, because it's not, in my experience, at all the case. Jody, you said that the average case was not Harvey Weinstein. Now, I'm working with Zelda Perkins, who was the first woman to break her Weinstein NDA. So obviously I know a great deal about what happened to Zelda and what was in that NDA and so forth. And, you know, as she will tell you, we both see NDAs exactly like Zelda's all the time, every week. multiple times every week. They are not different. And I think that one of the things that's become unfortunate about this discussion is that people think, oh, that was in the old days. That was how they used to do it in the old days. It's exactly the same. Clause by clause, it's the same. The only thing that would be different today, and people I think are a bit more sensitive to than they were when that happened to Zelda many decades ago, is that she was prescribed from reporting to police. I think most people have enough common sense now to know that putting that into a contractual agreement is pointless and unenforceable. But that is the only thing that's different about what she signed and what I see all the time, because I have a large and growing collection of NDAs. So just to say, it's happening now too.
Thanks very much. Any other responses? I then,
I
go ahead,
wanna
Jody.
respond. I actually didn't know what was in Zelda's NDA, and obviously the preventing reporting to the police is unconscionably void as a matter of public policy. But what I meant was not so much that her NDA may have been unusual, but that the serial nature of his criminal and sexual misconduct is unusual in that it is not your average case. There are serial harassers, to be sure, and they do manage to get from workplace to workplace. But these high profile, high media attention cases where there's just these, just so many cases that it's mind-boggling against one individual, that that makes it a bit unusual. But that's interesting to know, except for the criminal bar, it's the same clause that everybody else signs.
So let me ask.
Yeah, and
one
I
question.
would just say though that Harvey Weinstein is different because he's very rich and famous. But part of the problem with using NDAs for these kinds of matters is that in my own experience, and in my experience as a survivor and working with other survivors and victims for a number of years now, virtually everybody who sexually harasses somebody does it over and over again. I mean, there is so much data that shows this now. It's a very small number of men generally, but they account for virtually all the harassment. So to be serially harassing is quite commonplace, which of course was what Weinstein did. And that the difficulty in with these NDAs is that person then just gets passed on to another workplace to do the same. And I can certainly tell you that I have detailed knowledge of numbers of cases in which this has happened to university professors, for example. They've simply been passed on and they continue to harass students.
I'd like to pose a question, maybe controversial. So not that controversial, but I think in my experience, a more common case of gender-based workplace harassment or something bordering on that, typically an employee will have many claims. So they'll claim wage disparity, they'll claim gender disparity, they'll claim maybe racial related claims. There might be a whole list of causes of action under federal, state, local law. And each of those causes of action has sort of different factual allegations. One of the dynamics that's at play in my experience often is that the employer, or maybe an individual who works for the employer, will generally deny all of them and generally say, nothing like that ever happened. And I'm sure that there are, in many cases, shades of gray, in other cases, maybe less shades of gray. But in a situation where there are shades of gray and where a defendant really does believe that, that the allegations are simply untrue, and the parties have agreed to a private dispute resolution process, there's genuine factual ambiguity about what actually happened. Is there no price at which that defendant can buy the peace of mind of knowing that those allegations will not become public? In other words, should it really be the public policy that those allegations, which may or may not be true, can be talked about at any time, and that even if the employer wants to give $100,000 to, or more than that, to the employee to settle the claim, it's still, the law should say, no, you can't settle that. So Julie, I'm curious what you think of that sort of a gray area hypothetical.
Well, first of all, I'd say that it constantly alarms me how much we shade the accounts of people who have been bullied and harassed as being ambiguous. It seems to me that, by portraying somebody as having multiple claims is kind of a way of dissing them. Whereas in reality, we know that a lot of these kinds of circumstances clump together in people's lives. I would certainly suggest that anybody listening who's interested goes and reads through some of the testimonies that we have posted on our website from people who have been asked to sign NDAs, and you will see some extremely common themes in there, and the ways in which workplace harassment and bullying and generally feeling like you are not going to be treated fairly, whether that is pregnancy discrimination, racial discrimination around salary levels. I mean, we see all of these in these stories, and there are many, many examples. But let me just say this, that if those allegations are really absolutely without fact, we all know there would be no settlement. I mean, Prince Andrew didn't pay off Virginia Giuffre today because he was an innocent man. I mean, come on, we all know this. So if there's a settlement being made, if it's so important to the defendant that they close this down, then it seems to me that the chances are, whether or not there's been an actual trial, there is a very good reason why that settlement's being made. And I also know from the victim side, the enormous barriers, and I've written about this in my book, the enormous barriers faced by people who bring these complaints forward. They don't do it to get rich and famous. They do it because they're trying to resolve something that has become, a hideous burden to them, and they want to ensure other people will be protected. And, finally, I'd say that I just don't understand why we feel that it's okay for somebody who has agreed to pay a settlement, who can't therefore, rely on the ordinary laws of defamation to defend themselves, because we do have a law for that already. Why, when they've paid off somebody, should they also be able to keep their identity secret so that what they've done to one person is not going to be repeated for others? I just don't think that is something that is ethical. And I think that there are many, many people who would say that this is the guilt that they continue to live with for having signed that NDA in the first place.
So I think that this might be a good point at which we'll make the transition, because the chat has been pretty active, I think, in terms of people raising questions. And the only thing that I want to be sure that everyone knows is that one of our goals in this program is, remember, it's the ethics of NDAs. And so at the end, each one of our presenters is going to share 1 to 3 takeaways that they hope you all will take away. And one of the things we've imagined is that many of those of you who are participating in this are yourselves mediators, for example. So what do we hope, what do our presenters hope will be your key takeaways from this panel on the ethics of NDAs? So please stick around till the very end in order to get those takeaways. So I'm going to turn over to you, Amy, to let us know how we should proceed in terms of the chat related questions.
Yeah, the chat is very active. So it's even hard to sort of pin down the different questions. There's so many good ones. I'm going to start though, sort of on that note, talking about ethics and takeaways. Jean Sternlight raised a really great question. How should a quote unquote good attorney explain NDAs, explain the pros and cons to their client? What from a client counseling perspective? I don't know who would like to take that one, but I think it's a very important question.
Not shockingly, I'm going to say something that Julie will probably disagree with, which is that I think that from a client counseling perspective, in many cases, I think there's not a harm in advocating for your client in the context of drafting settlement agreement that such a clause be included if that's to your client's benefit. And I think that's true for 2 reasons. There may be some questions about enforceability later on, especially if various laws are passed, which of course will undermine their enforceability. But there's still a signaling function that clause could have in an agreement that could get the parties to behave voluntarily in a way that would be to your client's interest. So I think from a counseling perspective, as long as the law is what it is in your jurisdiction, and of course you have to follow the law, you can't include a provision that is inherently unenforceable, or you shouldn't ethically. But as long as that provision is enforceable and would be upheld in a court, then I think there's nothing ethically wrong with counseling your client to include it if it's in if it's in your client's best interests.
Anyone else care to weigh in on that? Other thoughts?
I would just say a couple of things about the client counseling dimension of this. And obviously, I don't do this as a practicing lawyer, although I've, as I say, I've done a lot of employment mediation, but I do talk to people now all the time who are often being faced with signing an NDA, and they have to make that decision for themselves. And I'm very, very clear about that. But two observations. One is one I've already made, which is that when people are right at what they think is the very end of a long and difficult negotiation, they're often in a hurry to sign that piece of paper and get out of there. I think this is something that's always tremendously challenging for us as mediators. And I think that in these cases, we have to start paying a lot more attention to this because of the second point that I'd make, which is that I've talked to people of all levels of education and smarts and experience who've signed NDAs. And I haven't yet talked to a single person who really understood the impact of what they were signing until much later. Sometimes that was because they simply hadn't read it. It was like some way at the bottom, appendix to the agreement. Sometimes it was because, yes, they'd looked at it, but they hadn't really thought about the fact that this was forever. And this was anybody. And this would mean they couldn't speak to anybody ever about what it was that had happened to them. So, that's not a very good record, really, 100% insufficient comprehension. And so I think that, if you're counseling a client in this situation, you really have to bear that in mind. And, saying, but this is how we always do it, isn't really going to cut the mustard when it comes to getting informed consent.
I would be very surprised that people represented by counsel sign things without understanding what they're signing. And I think that would be a failure on the part of the legal profession or the lawyer not to fully explain it. So I don't know if the people you're talking to are mostly unrepresented people.
No.
Or do they include represented people?
They do.
Who were just
And
told,
I mean, I'm
sign,
sorry,
sign.
Jody, there are some fantastic lawyers out there, and I'm sure you do this differently. But I can tell you that most of these people are represented, and their lawyers were much more interested in getting their signature on that piece of paper and getting their settlements cut than they were ensuring that they understood the NDA.
Well,
It's shocking.
That's sad and shocking, but what I take from Me Too's lesson of believe women to be stop automatically disbelieving women, but which is what happens in our society and all the gender and racial bias that is inherent in our society. But there's still, on the due process point of view, pre-litigation, pre-discovery, it's just very practically difficult, as I think Brian spoke to get employers to pay significant money if this thing's going to be on social media the next day. And I do think that the criticism NDAs have, received rightfully with the Me Too movement has really weakened NDAs in some respects that I just don't think, we have public, famous cases of them being disregarded and that people are breaching, they're not NDAs and speaking on social media, and not a lot of bad stuff's happening to them despite the onerous terms in their agreement. So I think we might see some pulling back from NDAs or strict enforcement of them in light of the social movement, which has really impacted the law to some extent in a very meaningful way. You know, for example, affirmative defenses, the number one affirmative defense for employers under federal law has been, you have a policy, and if your plaintiff doesn't follow that policy, well then, too bad. She's out of luck, and you have a defense as long as you had a policy, and it's her damn fault for not using it. That is changing. And there was a published decision, I know we don't want to be overly legal here, but in the Third Circuit here in the US, after Me Too, that said, wait a minute, I'm not going to, in light of these social media revelations, I'm not going to assume that this woman was unreasonable for not following your process when she saw this guy harassing other people and getting away with it. So it seemed futile to her. She feared retaliation. She needed her job to support a disabled child. And so the Third Circuit said, no, we're not going to apply this defense, literally, because we know that things don't work so well in the internal process front at companies. So I think that's an encouraging, I think, you know, the law is always very slow to catch up to the culture and social movements, but I do see NDAs as having been wounded somewhat, even without outright bans.
So there's a couple more themes that have emerged in the chat. There's actually a lot. We have like 3 hours worth of questions that we could bring to bear. They're really excellent questions, by the way. But one thing we haven't had a chance to really dive further into is this question of carve-outs, right? And I know there's been some discussion among all of you and in the chats as well. And I wondered if anybody would care to weigh in on the issue of carve-outs, and especially in light of, you know, party autonomy, power imbalances, some other themes that have kind of come up in the chat.
I can say a couple things on that. So on carve-outs so in terms of a general prohibition on NDAs, what would we carve out? I completely agree with what Jody and Julie have both said at various points, that if there is an NDA, it needs to be mutual. I think one of the challenges is that in a mediation, and I see there's a comment in the chat about party self-determination. So the challenge is that when I say it needs to be mutual, parties can agree to whatever they want in the context of a mediated settlement agreement. But I think from an ethical perspective, a mediator would do well to encourage an NDA to be mutually binding on both sides. I think that's more challenging when the defendant is a company rather than a defendant being an individual, for example, a manager at that company. Because when you bind a company to an NDA, you have to be very specific about what it is that they can't say about a current or former employee. But I still think that mutuality is a really important carve out, and it provides an opportunity for mutual education by a mediator about what actually are we talking about, what information can't be disclosed. To Julie's point, I can't imagine that any employer really cares if a former employee talks to their therapist, for example. To me, that seems like I would, encourage a client to say, who cares? They're covered by a separate protection. Maybe Julie's going to tell me I'm wrong, but I can't imagine that a business would be super concerned about that. So if that were a carve out, I would see that as being completely fine, something that would benefit both the employee plaintiff and the business. Yeah, those are two things I would emphasize: mutuality and exclusions for specific individuals or groups who you could disclose to.
And I'm wondering if Jody, I know you had some very specific examples when we chatted before, if you wanted to share some kind of specific ideas.
Well, I think, as I mentioned, the standard carve-outs are for your legal and financial advisors, provided they keep it confidential. Spouses are common. I've seen a movement towards immediate family. As I said, a hospital system put in therapy, your therapist or your counselor. which I thought was progressive, and I'm going to always insist on that. I mean, as a practical matter, people can talk to their friends. It's only going to come to light and have the NDA come back to bite them if it's made public. And, you know, we all know that you can talk to 100 or 10 of your closest friends who will then tell somebody else who it can get onto social media. It can get into the media in many ways. But for the most part, for people to feel, for victims to feel that I can never utter another word about this to anybody for the rest of my life, that's cruel and completely unnecessary. But employers, or I guess parties, I should say, you know, they want blunt instruments versus nuanced agreements. And you know, the fact that they're indefinite is also, I think, problematic, and they don't have to be indefinite. And I also think that people, this pass the trash notion that Julie talked about, I've heard of that in the context of child abuse and pedophiles moving from school system to school system. I think that people are just a lot less tolerant for that now. And, you know, if somebody, and that those perpetrators are not going to get good references and big giant settlement packages. And I know you're shaking your head and it still happens, but I do feel that, you know, it's getting a bit more nuanced, and at a minimum, if the person's lawyer is not really explaining this, the person who's mediating this certainly needs to be, and putting a focus on it, even if the other parties aren't, I think, because it's just so important. And it lasts forever.
Can I just make a couple of points to what Brian and Jody have said? I mean, I absolutely agree, Jody, they shouldn't be indefinite, but the problem is they are. And I completely agree, Brian, that they shouldn't, you know, prevent people from talking to their therapists, but they frequently do. I can show you an entire collection. I also completely agree. You know, this was something that was a revelation to me when I first started talking to people and doing some empirical research in this area, that of course people don't have video cameras at their kitchen table if they want to chat over a cup of coffee to their friend. But the really important thing I want to get across, and if you go read these testimonies, you'll see it, that's what people believe. So they are believing something that the chances of them being exposed, and remember, the people who've written the testimonies are people that we've persuaded we can anonymize and non-identify them. And I get at least 4 times as many people who don't write testimonies because they're still too afraid to do so. So the fear really is there. And, you know, in response to your point, Brian, you know, I suppose I'm just a little bit more skeptical about the employer's motives here, because I think their motive is to scare people. I think that's exactly what they're doing. And I think it is tremendously effective. Now, I think we can all agree that one of the reasons that this has taken off is social media, is the fact that there's all this stuff out there that you can, you know, put all this stuff out there and people will be known. But you know what? I don't like it very much either, but social media is a fact of life. And there's nothing that employers are going to be able to do about that. And we do have laws that prevent people from telling lies and untruths about people. They're called defamation laws, other than when they're in Trinidad, but that's a whole other story. They're called defamation laws. So just a quick word about the non-disparagement clauses and this idea of carve out. First of all, if anybody wants to take a look at the model bill, which I've dropped into the chat, I've put the Irish version in there, you'll see that there is a list of exempted people. So part of this legislation is saying no NDA can include a prescription against talking to your therapist or a police officer or a regulator about a complaint, et cetera, et cetera. It's kind of all set out in there. But I think that the problem with redrafting NDAs is the same problem that I faced when I was being asked to sign a non-disparagement clause by my own university. I tried to redraft the non-disparagement clause and send it back to them and say, let's have a non-defamation clause. I'm not going to defame you. And I simply got back, oh no, we want you never to say anything that we might deem to be negative at some time in the future. It's like, how can I possibly do that? And why should anybody be being asked to do that? So I think we have to be clear here on what we can carve out. And I agree, we can carve out some things, and what really is irredeemable. And I think any kind of a clause that says that somebody can't say something that the other side might feel is negative is just an absolutely ludicrous overreach into people's ability to express themselves, even if they're doing it on dreadful social media.
So it seems like the segue now, we're in our final 15 minutes. So this is the part you've all been waiting for. So the lightning round, if you will. We would like each of our presenters to give 3 main takeaways toward the ethics of NDAs and arbitration and mediation. And I think this is where we all can take copious notes, and this will be the highlight of the event. So how about if we start with, I think, Brian, you went last, or did Jody go last before? I think so. We can start with Jody. Yep.
So my 3 takeaways for the many mediators in the room and myself, when I can avoid disputes, is, to treat the NDA issue seriously. And even if the parties are represented and nobody's bringing it up, to make sure that the party, and particularly the plaintiff, understands that this is forever and this technically means this and that, because sounds like you can't, even parties represented can't count on their lawyer to do that. And certainly for unrepresented parties, it's even more critical that the issue of an NDA does not become an afterthought after the money is settled. And I think there are many, 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 many cases where that is true. I mean, I wouldn't do that, but it happens, I understand. And that's number 1, pay attention to it and raise it, even if nobody else is. It's important, as important as the money, that it should not be left to the drafting phase when there's a commitment on the money and nobody wants to walk away. And point 2, really explore the interests on both sides and to what extent it's necessary. And while exploring the interests, explore, broad carve-outs. And finally, for people who truly want their day in court and who do not want to be gagged, parties should, litigate. That if you do not want to be silenced, you can assure that by litigating or settling after the facts are in a public forum, because it's, gag orders are not for everybody.
And Brian, 3 points.
Sure. So my first one, I think, will be maybe disagreed with, and I think my second 2 are hopefully consensus points. That's the way I'll structure it. So my first one is, be skeptical of efforts to legalize alternative dispute resolution, by which I mean, I'm naturally, as I said in my opening comments, I'm a big fan of the belief in party autonomy, especially in mediation, where there is mutuality and consent and particularly representation on both sides. I'm skeptical of efforts to try to infringe on the parties' process when the parties themselves are the ones who know what is best for them, and their lawyers have a responsibility to ensure that that is true. So I'm generally skeptical of efforts to impinge on what we all think of as traditional ADR. Number 2 is, I would say, and this is some consensus points, hopefully, mediators. So those who are mediators on this call, I think there's an ethical responsibility responsibility to educate both sides on what the terms of a potential agreement might mean. So I know that there are ethical questions about what legal advice can a mediator give. So yes, it's true that a mediator maybe can't say, an NDA is definitely enforceable or an NDA is not enforceable. But I do think a mediator can reality test and can ask those questions of counsel and of the parties to make sure that the parties both on both sides of the aisle do understand what an NDA or a non-disparagement clause actually means in practice. And I think that education alone would solve many, if not most, of the problems that are being identified by this program. And finally, third, I think that lawyers have an ethical responsibility on the employment side, on the employer side, to advise their clients of the climate in society. And that means both to advise them on changes in the law, efforts such as those by Julie, the efforts in Congress. I think it's important that when employer side lawyers are advising their clients on employment agreements and policies, that those employers are aware that we're in a shifting moment right now. And then I think on the cultural side, similarly, employers' counsel should advise them that they may not look so good if they're trying to publicly enforce or compel arbitration in many situations in a way that could have really negative public relations impacts on the company that may be non-legal but still serious. So again, first point is maybe more controversial. Second point, I hope, are perhaps consensus points by my co-panelists.
Great. So Julie, the lightning round, 3 points.
Okay. Well, I found something Brian and I agree on. We agree that NDAs are increasingly bad for brands. So here's my first takeaway for people working in mediation and arbitration: get ready for change. Because this movement to legislate about the most egregious forms of NDAs in harassment and discrimination claims in particular is really gathering steam. I mean, this is happening far more quickly than anything I've ever worked on before. It's very exciting. I want to make sure we get it as right as we possibly can. All input on the model bill is very welcome. I think some of you will find it interesting to look at the structure of that. But in the meantime, when you're getting ready for change, I hope that this session has gotten across that you need to educate yourselves as mediators and arbitrators and learn more about the way that NDAs are being used. There is, for example, increasing amount of US case law that we haven't talked about today that shows that the courts are becoming very skeptical about the enforceability. And I mean, I see NDAs that, quite honestly, as a 40-year contracts law professor, they're almost laughable. I mean, there's just absolutely no way that they would be enforced, yet people still believe they're enforceable, which is why they adhere to them. So I think that's the kind of thing that it's really important for mediators to educate themselves on and just to be aware of that. The second point, and a lot of people have raised this in the chat, and I see Colm Brannigan is there. Hi, Colm. This must be like decades, so lovely to see you. And I'm also a big fan of what Brian calls party autonomy, what Colm calls self-determination in these negotiation processes, absolutely. But what I'm trying to bring to you today is the information, the data that shows that people do not have autonomy and self-determination when they're looking at NDAs, if they are the less powerful party. And there are enormous power disparities. I mean, we know this in many of these bargaining arenas. So I think it's really important for mediators to think about that power, to think about the need to ensure that a plaintiff understands the consequences of what they're signing, because you cannot take it for granted that their lawyer is going to tell them. And I know that we all have concerns about crossing a line ourselves in terms of giving legal advice. The way that I've always dealt with this in other issues, and I think you could do the same here, is not to give advice. I don't think this looks enforceable, have you really understood that this is indefinite, that kind of thing, but to ask questions, to say to the lawyer, have you talked to your client about the indefinite nature of NDAs? Have you talked to your client about who they will be allowed to speak to and what the consequences will be if they breach? I mean, I think that you can do that very effectively by asking questions as a mediator. And I do think that that's absolutely critical to maintaining some kind of agency and self-determination for the least powerful parties here. And then finally, this is probably, you know, the most controversial point, but it's just so tempting to point it out to mediators. This idea that without an NDA, I can't, won't, will not settle. This, you know, ultimatum kind of framing, which is so familiar to us in so many other guises. It is, of course, if you think about it, in relation to the defendant making this argument, it is, of course, a giant bluff, because the only thing worse for the defendant than the other side not agreeing to an NDA is taking it into the public domain and arguing about it in court. So it has long been my suspicion that people who push back against NDAs and say, no, that's okay, you know, take it to court, get settlements anyway. They just get them without NDAs. And I have a growing number of files now that I'm collecting in which exactly that has happened, because it's not in the interest of the party who wants the NDA, the employer, to go to court anyway. And in a way, it's a giant bluff. Now, should mediators be pointing that out? Should they be asking questions like, well, I'm sure you appreciate, or your client appreciates, that this is going to get much more public if you continue and go to court, whatever it might be. But it seems to me that there is a kind of elephant on the table there that people don't talk about when it comes to the scare tactics and the bluff that's being used for NDAs. And this is something for every individual mediator to decide where they're comfortable. But I think it could be something that you would be at least drawing to people's attention. Thanks.
Well, that was wonderful, don't you think, Amy?
Oh, absolutely. I mean, this has been a really fantastic conversation. So many great takeaways, lots of, yes, I just want to thank you all from the bottom of my heart, and Nancy, I'm sure same from your heart. Thank you all. This has been a tremendous conversation. We could talk another 3 hours and bring in other issues that I would love to ask. So just thank you so much. Really great information.
Yeah, thanks from me as well. And I will take away from this the image of an elephant on the table, I have to say.
I know.
And let me just add that the chat comments have been wonderful, and they in and of themselves, I think, offer some additional information and ideas. What a wonderful idea of having a sample clause that might have choices regarding all these different carve-outs. Wouldn't that be, and make it easier for a mediator to suggest that people think carefully through all of these issues? And Gilad Bashar, I know, is someone who at least was here, and she is among those that's collecting data in connection with people's perceptions of non-disclosure agreements. So thank you to everyone who, all of our presenters, and also to everyone who participated in this, and we look forward to whatever the next step happens to be.
Yeah, stay tuned. I think there should be, maybe regarding the law and how it's going to work. What about discrimination claims now that we have sexual harassment covered? I think there's going to be a lot more to discuss, so stay tuned.
Great. All right. And thanks again to Colin, because none of this would have happened without Colin Rule.
Yes, thank you so much, Nancy and Amy. Thank you for an excellent job. And thank you to all the presenters.
Great.
Be well, everyone. Thank you.
Great.